Hi, everyone. My name is Dave Zapponi, and I'm the CEO of ECHO, otherwise known as the Educational Council of Homeowners. I want to thank you all for coming today to our community conversation on difficult people conflict resolution strategies. ECHO is a statewide nonprofit association established to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connections. For today's event, we have a few housekeeping items. These are now presented on the screen. In addition, the slides were sent to registered attendees beforehand. Please take a moment and review the housekeeping items. We have a large number of HOA attendees today, which usually means a lot of questions. We will do our best to answer them. Please use your Q&A icon, not the chat icon, to answer your questions or make comments. You should use the chat icon to report technical issues and to communicate directly with other participants in the webinar. You will find these navigation icons by hovering over the bar at the bottom of the page. Jean will be answering a few questions during her presentation. Afterwards, we will address most questions during the Q&A session. I will respond in writing to some questions in the Q&A feature during the presentation. Please keep your questions general in nature. Questions about specific situations are better asked one-on-one. To help us select the most relevant questions for this audience, please use the thumbs up icon found on the Q&A screen in the bottom left corner. Simply click this upvote icon to select your favorite questions. And now for our disclaimer, which you'll find on the screen. None of what is said during this seminar shall be construed as specific legal or expert advice from the speaker's sponsors or ECHO. If you wish specific advice, we encourage you to contact your attorney or another suitable expert. Thank you. Today we have several sponsors. Please join me in thanking our premier sponsor, the Kevin Boland Insurance Agency, and our Q&A sponsors, Eugene Berger Management Corporation, and CID Consortium. Our registration sponsor is Levy Erlinger and Company CPAs. Now we will have a few words from our premier sponsor, Kevin Boland of the Kevin Boland Insurance Agency. Connor?
Hi, everyone. My name again is Kevin Boland, and I'm really proud today to be the sponsor of our ECHO educational webinar. Today's topic is on conflict resolution. And I can share with you from an insurance agent's perspective how important it is to be more cooperative and combative when it comes to dealing with unhappy homeowners. I also serve on my board, so trust me, I've had a lot of personal experience. So what happens is if there is a breakdown in escalation or communication between the board and an angry homeowner, that homeowner, and I've seen it a few times, can actually sue the board and claim all kinds of things. And the good news is your insurance under directors and officers will defend you. However, we all know what happens if there's a big claim and it costs, $50,000, $100,000. A year later, your insurance rates go up. So we don't want to go there. So I'm really looking forward to learning and sitting back today and picking up as much good tips as I can about conflict resolution. And of course, if anybody wants an insurance review this year on your association, you can always reach me in the ECHO directory or at www.kevinbolandinsurance.com. Thank you.
Thank you, Kevin. And thank you to all of our sponsors today. They make this event affordable for all. Session 1. Our webinar today is Difficult People, Conflict Resolution Strategies, presented by Gene Grove, Esquire of KDV Law Firm. Gene Grove focuses her practice on real estate and business litigation, including HOA and co-ownership issues, purchase, sale disputes and non-disclosure claims, and boundary line, title development and construction matters. Her representative clients include homeowner associations, real estate brokers, agents, developers, lenders, property owners, and business owners. Ms. Grove offers her clients nearly 2 decades of experience in mediation and arbitration, as well as all phases of civil litigation. Based on her deep litigation experience, Ms. Grove regularly counsels clients such as HOAs on how to avoid conflicts by strategically managing their day-to-day operations and compliance matters. Jean, it's all yours.
Thanks, Dave. So I will preface my presentation with just a brief overview of what I'll cover. First, I want to at least address the parameters of the law, the governing documents, the relevance of all of those things, and how they may inform how you move forward with any kind of conflict that arises in HOAs among people or among the homeowners, for example, or even between the HOA and its board vis-a-vis a homeowner. And then I will, after talking about that framework, talk about real life cases, some lessons learned that I have also developed over the years as we mediate these issues and resolve these types of disputes, some overarching lessons that we can all use going forward with HOA disputes. So without further ado, Connor, if we could move to the first slide. Governing law. So of course, one of the most important legal frameworks that we all need to be aware of is the Davis-Sterling Act. Note that the Davis-Sterling Act requires a fair, reasonable, and expeditious procedure for resolving a dispute. That's Civil Code 5905. Separately, under Civil Code 5930, there is a requirement for alternative dispute resolution, which I'll refer to from here on as ADR for short. And ADR is a prerequisite to pursuing any kind of enforcement action. And keep in mind, ADR can include mediation, arbitration, or as defined in the statute here, conciliation or other non-judicial process that involves a neutral party in the decision-making process. Now, let me unpack that briefly. First, all HOAs must offer what is stated as a fair, reasonable, and expeditious procedure. That can mean mediation. So for example, if the CC&R say any dispute must be first resolved or the parties must first attempt to resolve a dispute through mediation, that actually satisfies that process, assuming it's adequately described in the CC&Rs, the mediation process would satisfy that first section, Civil Code 5905. It also happens to satisfy the ADR requirement under Civil Code 5930, so that if there's, say, a violation of the CC&Rs and the HOA wishes to pursue that violation, if they first attempt to resolve that dispute and that violation in mediation, they have satisfied both sections of the Davis-Sterling Act, both 5905 offering a fair, reasonable, and expeditious procedure, and then also satisfying the ADR prerequisite before pursuing the enforcement action. Now, many CC&Rs may have what's called IDR, internal dispute resolution. IDR, just for everyone's edification, is not actually a statutory term under the Davis-Sterling Act, but it has become a common practice to participate in what is effectively informal dispute resolution. And informal typically means, not always, but typically to differentiate from mediation, for example, it typically means there is no third party neutral. Most often it does not even involve, IDR does not even involve attorneys for either of the parties. And the goal, of course, is due to the informality of the dispute resolution process, that folks can just talk and try to work out a dispute and resolve it, right? Another term which actually is used in the statute is a meet and confer process. So meet and confer is analogous most often with the IDR process, and you might see one or both terms used in CC&Rs. And that does satisfy the quote unquote fair, reasonable, and expeditious procedure for resolving disputes. So it's important to know these terms just so you understand the parameters for how the statute, at least the Davis-Sterling Act, requires and really encourages parties to resolve their disputes, or at least try to resolve their disputes out of court before resorting to a court process or some sort of litigation. The other governing law to be aware of is the Fair Housing Act and the Unruh Civil Rights Act. And that just provides the overarching standard that one cannot discriminate or harass based on all these various categories that I've listed here in this slide, including, among other things, race, color, religion, sex, etc. It's important to also understand just generally that there are these laws out there and that they often inform how one must or should handle disputes, especially if there is a claim by a homeowner, for example, based on a disability, a request for a reasonable accommodation, or a complaint of discrimination or harassment based on one of these categories. What I will not cover, but just important for everyone to understand, is that assessment disputes are, of course, a very common HOA type of dispute. That is the subject of a completely different topic, so we won't cover that today. But keep in mind, there's often overlap. When there's an assessment, a delinquent assessment, for example, it might be intertwined with a difficult person. And so you might have to deal with various overlapping concerns, such as, on the one hand, needing to promptly pursue the foreclosure process for delinquencies, and then on the other hand, dealing with the difficult person and how you resolve that type of conflict. Next slide. So governing documents are the other framework to be aware of. In addition to the governing laws that we covered, of course, we have to look at our governing documents, which include the CC&Rs, maybe also the bylaws and operating rules, to the extent that that informs the procedures for how to handle disputes and violations, etc. And then you have to look at them in harmony with the governing law. So one common example is under the Davis-Sterling Act, as we just addressed, it only requires one form of ADR, which is either that mediation, arbitration, conciliation, or other non-judicial process. What can often be confused is CC&Rs commonly require both mediation and then arbitration. And often how it's described is, if there's a dispute, parties must first attempt mediation, and if they are not able to resolve their dispute, they move to arbitration. But keep in mind, that's what the CC&Rs may say, and they are allowed to require more than one form of ADR. Davis-Sterling Act only requires a minimum of one form. So it is very possible, depending on your governing documents, that they only require arbitration, for example, and don't require mediation. And when you're in that situation where perhaps it's optional to pursue either ADR or even an informal IDR, meet and confer process, it's important, and we'll cover this in a minute, whether it's a good idea, even if it's optional, to consider these other forms of dispute resolution procedures. Next slide. So what is mediation versus arbitration? I want to take one step back to just make sure we're all clear on what that is, because it is often used and often confused with each other. So as we stated, mediation and arbitration are two forms of allowable ADR procedures under the Davis-Sterling Act. You only need one of them, or at least one non-judicial procedure that involves a neutral third party that attempts to resolve the dispute for you. But they are very different. And keep in mind, because they are different, you really must be careful when you're reading your governing documents, whether they require mediation or arbitration or both. And what can also be confusing is a lot of CC&Rs merely repeat or incorporate the statutory language, which we just covered in that first slide, allows for any one of those forms of ADR. That makes it even more confusing, because if the CC&Rs merely repeat the statute, then theoretically it is a decision, an optional decision for the parties involved in any given dispute, whether they're going to agree to mediation for that particular dispute or arbitration or some other non-judicial procedure. So just keep in mind, there is no one size fits all when it comes to these CC&Rs because of the way the statute is written. Next slide. Mediation. So very quickly, mediation, or any non-judicial procedure for that matter that involves a neutral party, is really just a formal procedure to attempt to reach a compromise and ultimately resolve a dispute between any given parties. That applies to any mediation for that matter. And then with respect to HOAs, it can apply to the HOA vis-a-vis a homeowner or between homeowners. And so the important thing to remember about mediation is it is not at all a binding process, in that there is no trial, there is no presentation of evidence, and your neutral third party has zero decision-making power. They have so little power that theoretically everyone can show up to a mediation, and these days it's via Zoom, and participate for all of 5 minutes. And if one party decides to leave or log off the Zoom, the mediator has no power whatsoever to stop that person from leaving the mediation. So really, the concept is that the parties in the dispute voluntarily, quote unquote, participate in this meeting in an attempt to resolve their dispute. The reason I say voluntarily in quotes is, of course, the statute may require it, or your CC&Rs may require it, but ultimately it's simply a settlement meeting with a neutral third party facilitating that meeting. It's also important to understand that all discussions in that mediation process are privileged. So as mentioned, no presentation of evidence. Certainly you may exchange documents, you may say things to each other, but all of those communications, and to some extent, sometimes the exchange of documents, can be privileged. There is no binding outcome, or at least no requirement that there be a binding outcome as a result of the mediation. But keep in mind, if everybody agrees on particular settlement terms and they reduce it to writing, then there is, of course, the possibility, in fact, it's the goal, to reach a written settlement agreement that everybody executes. And then that written settlement agreement does become binding and enforceable as to all the parties who have signed. Next slide. Arbitration, by contrast, is an out-of-court procedure that is fashioned very much like a trial, at least like a bench trial. There's no jury, of course, and there's officially no judge involved, but often arbitrators are retired judges. They can sometimes be attorneys. Typically, they are an experienced attorney of some kind, ideally with some familiarity with the subject matter, such as the dispute at issue. And that arbitrator gets to make final decisions on the dispute. Most of the time, at least for purposes of HOA disputes, that arbitration is binding. So the arbitrator's decision cannot be appealed. It is the final decision. And assuming it's a black and white question, did that homeowner violate paragraph 6 of the CC&Rs, and what is the consequence of that? The arbitrator is making very black and white decisions similar to a judge. And because it is like a trial, of course, there is some procedure of presenting evidence, often an oral hearing where witnesses testify. These days, of course, they happen more often virtually, but the concept is that there is some presentation of evidence. And the way the procedures are run are very much in the discretion of the arbitrator. So it's important to understand that this is technically a type of dispute resolution process as recognized under the Davis-Sterling Act. Next slide. So what happens if your case lands in court? This is assuming you have, as the parties, either exhausted all of your ADR requirements, or that, for example, there is no arbitration requirement, which would mean that unless you have settled the case beforehand, you would presumably go to trial, or you would file a lawsuit in the local courthouse and ultimately be angling towards trial to get a final decision by the court. In that case, there is a question whether there's a jury and or a judge deciding the various issues at trial. But keep in mind, just as a practical matter, even if your case winds up in court somehow, that the courts are built such that they have the power to mandate mediation. They strongly encourage settlement before trial in general. And my percentage here is purely anecdotal based on my own practice, though also somewhat an informal poll of colleagues who practice in this area as well. 90% plus is probably a conservative percentage of cases that settle before trial. I often say it's not a question of if, but when you settle. And that's simply because the way the courts are built, they not only have the power to mandate mediation, but they also often force parties to show up for a last-minute settlement conference right before a trial begins, if not much sooner. And so the way that cases are litigated, the reality is these type of cases settle before trial more often than not. And much more so in this pretrial conference. That's what I mentioned about a settlement conference at the last minute. That 90% goes up significantly to maybe even 99%, I would safely say. That's how often cases settle before trial when it comes to these types of HOA disputes. And the reason is because often the stakes are simply not worth going through the expense of trial. You're often dealing with personalities, often very strong personalities, and sometimes it's not even the legal issues anymore, it's about the people involved. And when that's the case, it almost makes no sense, at least from an economic standpoint, to try a case like that. And that is a big reason for why these cases settle before trial. Next slide. Okay, so the question here is, what if it's optional to pursue an IDR or an ADR or a type of ADR? Let's say it's a set of CC&Rs that merely repeat the statute. In general, based on my experience, if you cannot resolve a dispute informally, if, for example, there is a clear violation that the board needs to enforce, or if there's been a pattern of misconduct by a homeowner, some other reason that it's important to take a formal approach to a dispute, in general, mediation is probably your best choice. Again, this is assuming it is an option under the CC&Rs. The reason is because, well, twofold. One is I would not recommend going immediately to arbitration in most cases, because that's basically your trial. There's no room for flexibility anymore if you're going straight to mediation or filing a lawsuit, much more so if you're filing a lawsuit. So that's one reason mediation tends to be the better choice. And on the flip side, if, for example, you're considering an informal process, but you know that there's a pattern of violations and it's time sensitive to enforce these violations. Let's say it's a DIY type of owner who is altering his or her unit and maybe undermining common areas of the building. That may not be a situation where a good talk is going to do it, but a mediation might be just enough formality to start the process. So I say that mediation is usually the best choice, but there are a myriad of exceptions where the less formal approach might be the better touch, and we'll get into that in the next slide. Okay, common issues that lead to conflict. So I mentioned that DIY homeowner, a handy person who's trying to alter without the approval of the HOA various portions of their unit, for example. The other one is a noisy neighbor. I'm sure we've all experienced it at one point in our lives. That, of course, was exacerbated quite a bit during the pandemic and shelter-in-place periods. And that can be a variety of reasons. It can be either small children who just are, have no concept of how to stay quiet, and it's an old building where the acoustics aren't so great in terms of sound insulation. Or it could be an intentionally noisy neighbor where they have loud parties without regard for their neighbors. Another common issue is an absentee owner who rents out to tenants and is not reasonably controlling the conduct of their tenants and allowing them to kind of run rampant and violate various provisions of the CC&Rs or operating rules. And then the more tricky one is a litigious owner. And usually you can sense that early on, where they're often prone to complaining. Maybe they document everything in writing with an email, and they're just always confrontational. So that is a common issue that a lot of board members have to deal with. Next slide. So some real life cases that I'll get into, and I mostly want to focus on the last 2 years just because they are the most current, and I don't believe that many of the issues go away, and I think they are still somewhat universal regardless of everybody sheltering in place. Obviously, the noise was a rampant issue in the last 2 years when people were kind of stuck at home more than they wanted to be. But that is a reality that I think even before COVID was a common issue. And noise, as I mentioned, can be generated by a variety of circumstances. If it is, in fact, loud parties, someone who's simply disregarding basic quiet hours that may be set forth in the CC&Rs, that's a somewhat easy one where you might just pursue mediation. You might, judging on the character of that homeowner, realize that IDR is not going to be productive and just skip it altogether so that you can get that much closer to documenting that case of violations and dealing with it as promptly as possible, particularly if you are on the receiving end of a litany of complaints from other neighbors about this noise. Again, this is assuming IDR is not an option or optional. Conversely, if the noise is on account of, say, children, or I had a case where it was actually a disabled child who was causing the noise, and technically it did amount to a violation. The noise was in fact because of misuse of common area. It did generate some complaints from other homeowners who just felt that it was unsafe for not only the child, but also for other surrounding owners. And noise was just one of the issues, by the way. It was mostly the misuse of the common area garage and generating some safety concerns, which were actually legitimate safety concerns. Now, in that case, you've got a disabled child and parents that are just honestly trying to raise their disabled child. I think he was under, or she was under the age of 7, 6, so fairly young. And both parents were full-time working parents, so they also delegated some of their parent-child care duties to a third party. Under those circumstances, I would not necessarily issue a notice of violation, issue fines, issue attorney's fees. That might be a situation where you might just take the human approach as a board and approach these parents and figure out a way to come up with a solution and be more sensitive to their situation with the disabled child. That would have been the ideal thing to do. Unfortunately, in my case, they did not consult me before a DFVH complaint was already filed on behalf of their disabled child. And what had happened was their former counsel did in fact issue the notice of violation and started issuing fines for the misuse of the common area, and went even so far as to demand attorney's fees associated with that violation. Technically, all of that was legal and authorized under the CC&Rs, but it probably was not the right move. And of course, it inevitably ended up in litigation because of the way that they reacted to it. So that's just one example. Another one is unauthorized alterations to unit. As I mentioned, that may be a situation where the more human approach is not necessary, because someone who is doing that presumably knows what they're doing it intentionally, and they're doing it to see how far they can get away with that type of conduct. That may not warrant a human approach, and you may want to consider issuing fines, issuing the notice of violation right away, and documenting that case. So it's really important to, unfortunately, exercise a little emotional intelligence and take this on a case-by-case basis. One more comment on the pandemic too, and I think it's worth noting as we hopefully come out of it. A lot of these homeowners who made claims over the last couple of years, the universal themes I saw were that they really needed to be heard and understood and make an impact on others. So one example was at a mediation by Zoom. We had a claimant, a homeowner, who was complaining about every single little thing that the HOA was doing or not doing. And of course, there were undertones of discrimination and harassment. The homeowner belonged to a minority category and had a basis to claim racial discrimination and gender discrimination. So with those undertones, we went into the mediation, and she felt the need to express her feelings. And it wasn't just the feelings of discrimination experiences that she was alleging. It was a lot of baggage that was clearly the result of this unprecedented time that we've all experienced. And so we gave her a full hour to just unload that. And after that, you could tell visibly, this was only on a Zoom, but you could just see on her face how relieved she felt. And it was the clear path to coming up with common sense solutions and avoiding litigation. And sometimes that's all folks need. And if you don't have to do that in a mediation, then don't. If you can just do that by letting the homeowner, the party who is complaining about something, if you can just let that person be heard and at least not necessarily concede, but at least try to get them to understand that you are listening and trying to see it from their point of view. Sometimes it's those human touches that can go a long way and avoid litigation. Next slide.
Hey, Jean?
Yes.
There's some people here that are asking questions about ADR and IDR, and they are interested to know if you use ADR and IDR between homeowners or if it's just the HOA board. I mean, maybe you can address that. And then there was another question about what if somebody has an alcohol dependency and they're disruptive and they're creating issues in the community. Is that a disability, or is there a special way to handle that? So a couple of questions there.
Sure, I'll take that one first with the alcoholic dependency. The reality is, unless the homeowner makes a claim for an accommodation of some kind, you have to just deal with the behavior as much as you can. So analogizing that to the disabled child case that we had, at least up until the time that the parents claimed a disability, the board had no reason to know. Certainly, one could deduce based on the disabled child's conduct that there was a disability at play, but there was nothing documented. So similarly, if that homeowner who has an alcoholic issue and is creating, has behavioral issues and perhaps even causing violations as a result, you have to just deal with what's concrete before you. And if there's a violation, certainly you have to deal with it in some manner. If the more human approach is the right way, for example, if it's some minor damage to common area and it was because they were under the influence at that particular time, maybe the human approach is the right move in that case. On the other hand, if they are risking the security of others, if they are actually causing harm to others, then you might need to take the much more strong stance and just keep constantly in the back of your mind that there may be a disability claim down the road, and to assume that it may be down the road, but at least do the best you can to protect the others in the building and enforce the violations as needed. So it is a fine balance. The second question was about IDR versus ADR. And I don't remember, was it if it's optional?
No, is IDR, ADR, do you use that process between homeowners, or is it always between the HOA community, the board, and a homeowner? Or when does it apply? When does it apply?
It can apply to both, all those disputes described. Of course, it depends on what the governing documents say. But assuming the governing documents are either silent or allow for all of those disputes to be resolved in that manner, then yes, the IDR meet and confer process can apply to disputes between homeowners as much as it can apply between an HOA board vis-a-vis a homeowner. Sometimes also keep in mind that, for example, with noise, some CC&Rs may just deflect that noise type of issue, assuming it's not a construction related issue, noise complaints to the homeowners themselves. So the HOA may not even be involved in that at all, nor is required to if the CC&Rs say so.
And then the governing documents may have a way to solve some of these problems too, I assume.
Exactly, yes. And also if the CC&Rs have, say, quiet hours or unauthorized construction hours and things like that, those will help inform how the dispute is resolved. Any other questions we should address at this point? Let's see. I see one about cameras, security cameras, and the fact that spying on vendors and possibly homeowners is just wrong. So I like this question because it does draw on a universal theme, especially in the midst of a pandemic. And that is the propriety of security cameras that are operated on behalf of the HOA, right? And these would be presumably installed in common areas. First of all, common sense is that the security cameras should not be pointed in a manner that would undermine the privacy of any of the homeowners in their respective units. This is assuming, of course, we have a multi-unit building in question. It can't be pointed at their front door, for example, right? But if the true intent is to maintain the security of the entire community, right? And let's say there's a front door lobby that doesn't go to a respective unit, but simply monitors if Amazon packages are being stolen or whatnot, or if there's a history of burglary into the building or broken windows or things like that, that's totally appropriate. And I will say that it caused more consternation, oddly, during the pandemic. And I think it's because people felt very isolated and didn't like it if, my guess is, if they were coming and going into the building amidst a shelter in place order, that they didn't like that there was proof of that, right? So in any event, if there's some independent reason that the board is implementing a neutral rule like that, such as installing security cameras, I don't really see any reason that a homeowner will prevail against that. Certainly, you might invite homeowners that are upset about it for one reason or another, but in that case, I think the position is pretty defensible.
Yeah, and I know of one situation where the HOA put the cameras in a reasonable location. I think one of them was taking the license plates going in and out of the property. But I also know that one of the downfalls of that was the association got sued because there was a situation of infidelity, and they were taking pictures of, and so it's discoverable, right? So all of this is discoverable. So you have to be very careful about how you do it and be sensible about expectations. So
that's right.
Yeah.
So if we want to go to the next slide, that does actually, that's actually a good segue to some general principles that I wanted to share to avoid conflict. Of course, it's important for you to be familiar with the applicable law. And if you don't feel comfortable with the laws that may apply to a particular situation, definitely get counsel. For example, if any homeowner is making a claim of a disability or is formally complaining about discrimination or harassment, definitely get an attorney to guide you on next steps. Of course, you have to be familiar with your own governing documents and rules. But here's another, the bullet point 3, another principle that I want to encourage, and it's not required, it's not law, but I strongly recommend that board members, maybe even property managers, anyone that's in a position that they are having to interact quite often with homeowners, that they all participate in some form of anti-harassment, sensitivity, diversity training. I will say personally, I participate in these and I always come away with something new that I have learned. And the most progressive of us may think that we know everything, but these trainings, there may be an hour at most of your life. It's amazing how helpful they can be, if anything, just as reminders of the right things to say, the wrong things to say, those types of things. And more that becomes important because people are just much more aware of the right and wrong ways to handle things. And it's amazing too how if you approach someone correctly, if you're even using the correct pronoun, right? Because that's really important these days for people to respect people's gender identity, among other things. And it's those little light touches that could, you'd be amazed, could go a long way in terms of forming strong relationships and avoiding litigation down the road. Of course, number 4, any lawyer is going to tell you to document everything. And so this is with a huge asterisk, right? If you're in a situation, of course, where there's a history of violations, or you know that someone, a homeowner, is prone to litigation and maybe filing suit, of course, it's important to document everything and keep a file. On the other hand, keep in mind that maybe you don't have to document every single communication, especially between board members. And it's very easy these days, as we know, to quickly send an email or a text, or there's a variety of different instant messaging platforms out there these days. And that's all well and fine when it comes to, sure, see you at 3:30 or those innocuous type of comments. But if you're getting into a substantive discussion where, for example, you're talking about a homeowner that you're sick of hearing from and you're saying potentially disparaging things about that homeowner, please don't do that on text or email or any kind of platform where it can be, it can come back to haunt you as in the form of evidence. In fact, even if it doesn't go that far, even if it's something like, we're going to do this, we're going to pursue this violation, and here's the procedure for it. If you're going to send that in an email, just always think this is going to be used as evidence. Am I okay with that down the road? So that's my big asterisk to bullet point number 4. Number 5 is decide a point person. So this is really important when you have either a large board or you just have different roles for different people. If there is either a litigious homeowner or just an issue you know is developing, try to pick your point person, whether it's the property manager or the president of the HOA, if that's appropriate, whoever it is, because you don't want to have too many cooks in the kitchen if there's an issue developing. Try to pick a point person if that's possible. Next is to respond with facts and do not react. So this is a little bit of the emotional intelligence comment I made earlier. It's so important to de-escalate these kind of difficult situations. And this is assuming, of course, there's no black and white violation that needs to be remedied immediately. If this is kind of that gray area where you know that, let's say there is a single mom with children, and yes, they are causing noise and generating complaints, but is it really appropriate to be slapping at them with a notice of violation or slapping the mom with a notice of violation? When you're dealing with that, remember that you're dealing with human beings at the end of the day, and you shouldn't be simply reacting and enforcing the CC&Rs every time, at least not immediately. And then conversely, if you do have someone who's just very emotional especially these days, there's a lot to feel strongly about, right? Don't reciprocate that. Try to keep focused on what is the issue that they're actually complaining about, even if you know that they've got a lot of other baggage that they are reacting to. If you stick to the facts, the most you can hope for is that the homeowner is going to circle back and focus on what it is they were complaining about in the first place. Part of that, of course, is active listening. There are classes out there. In fact, if you're going to look into sensitivity training, it might also be worthwhile to look for courses. They're often targeted to mediators, but certainly not limited to them. And it's just about how you actively listen to others so that you can have a productive discussion and allow that other person to feel that they are being heard. And then, of course, to be empathetic, but at the same time, to not lose sight of the enforcement measures and keep in mind how you're going to stay consistent in terms of applying the rules and the CC&Rs. With that, I think that was my last slide. Connor, is that right? Yep.
Yes, it is.
So we can take more questions. Dave, do you want me to just dive into the Q&A here?
No, I was there answering questions, so I'm a little bit asleep at the wheel here. So let me go ahead and get to where I'm supposed to be. A lot of really great questions and a lot of things that we need to be talking about in our session. So this will be the Q&A session, and I want to thank Eugene Berger Management Corporation and CID Consortium for being our Q&A sponsors for today. Short reminder to use the upvote feature in the Q&A on the Q&A screen, and you'll be able to just see it on the bottom of the screen there. Hit the upvote on your favorite questions so that we can prioritize those questions, and we'll go ahead and get rolling on those right away. This will help us to prioritize it. So let's go ahead and do that. I'm going to bounce out of this and get back to the Q&A sessions, and let me go to the top. I'll give you a couple seconds here. Let's give you 5 or 10 seconds to go ahead and pick your questions to Gene, and we can just kind of get settled in here, and we'll get rolling on this. We have a lot of time. We have quite a bit of time left to answer a lot of the questions. I know there was there's questions of a lot of good questions about the individuals that are creating problems in the community, and the alcoholism was one of them. There's also the mental health of some of these folks, and it's like, well, how do you know that they're crazy or they're just a little different, or what's, and I'm thinking that's like a slippery slope for people. So maybe you can talk a little bit about what the hurdles are for those determinations and what you need to do. Usually when I get those calls, it's like, be very careful, call your attorney, because they're going to be able to make sure you do everything right, because it's just too dangerous or too risky for the association. But how would you deal with that?
Well,
what are the hurdles?
Right, and I agree with that. When those type of cases cross my desk, assuming there's no formal disability requested or identified, we always assume that may be identified down the road, and we treat the case accordingly, right? But assuming you don't have counsel involved, or maybe you're just dealing with it on kind of an early stage where you're just dealing with the behavior, the reality is, unless there is a formal disability identified, and this would have to be identified by the homeowner itself or a representative of the homeowner, you just have to deal with the behavior on a case-by-case basis, right? So if there's damage to common area, you have to address that accordingly. If they're causing harm or threatening harm to other owners and occupants of the community, you have to address that accordingly. And I saw there was a question about, do you involve the police? Absolutely. If there is an immediate threat of harm, definitely involve the police. And that is one way of documenting the behavior, after all, and timely keep maintaining the security of your community and its members, right? So that's unfortunately the way you have to handle that. Now, unless and until there's a formal disability identified. Now, if the homeowner or its representative sometime thereafter says, we need a reasonable accommodation, you can't be slapping all of these notices of violation against us, here's the reason, and they give you just enough information. You're not entitled to a whole lot, by the way, as far as medical records. But if they satisfy the threshold for a protected class or disability, then the next question for the board, and this is where you absolutely should be engaging counsel, the question is, how do you reasonably accommodate that? And remember, the key is reasonable, right? So it is not reasonable to just allow the conduct to happen and allow that homeowner to threaten physical harm to others, right? Or damage common area. But there might have to be some parameters, and really it's a fact-based inquiry where you would have to solicit some proposal from the homeowner or its attorney or representative as to how they expect you to reasonably accommodate them. Now, of course, a simple answer might be, well, we'll waive the fines, right? We're not necessarily going to fine you for all of this behavior, but you have to stop the behavior, right? So that would be a reasonable accommodation without necessarily backing down and undermining your obligations to the others.
Okay, well, here's a really popular question, 15 upvotes, and that's with Mark asks, if a homeowner requests an ADR to dispute a fine, but then fails to schedule the ADR when our attorney reaches out to them, how long do we have to wait before the fine becomes active and the homeowner can be held not in good standing if they refuse to pay the fine?
Well, that all depends on the governing documents. In general, now boards cannot reduce the homeowner's good standing on account of a fine as opposed to delinquency for dues, right? But is there a timeline? It really depends on most likely the bylaws or maybe the CC&Rs, whether and under what time frame the board is obligated to respond to a request for ADR for a fine. Very different from a delinquency, for example, where the board actually must offer a free, meaning the homeowner does not pay for that fair, reasonable, and expeditious procedure, such as mediation, to discuss the delinquency.
Mm-hmm. So in essence, it's up to what your governing documents say to determine when it's enough is enough. The other thing is, if you have your attorney involved, they should be able to tell you that.
Exactly, right. They are most likely reading your governing documents and can tell you.
That's why you have the attorney. So, that's a good way to go. So let's take a look at this next one. Anonymous. Anonymous comes a lot. What if the owner does not have any real issues, but just because they do not agree with the board decisions, they want to do an IDR? Per Davis Sterling, the HOA cannot refuse an IDR. Does it make sense to have the HOA attorney present? Several such IDRs without an attorney have not resulted in an agreement because it is the board's duty to make the decisions.
That's a good question. And again, this assumes there is no IDR necessarily required under the CC&Rs. And so I'll take each example one at a time. One is if the board is obligated to offer the IDR, the meet and confer process without a neutral third party, for example, then definitely offer it to them. Of course, if that's required under the CC&Rs, whether the homeowner should bring their attorney, and again, this would be more a question for the homeowner, really in the homeowner's discretion. The board should not deny, of course, the attorney's participation, but by the same token, perhaps the board should have its own counsel present for the IDR process. If it's elective, though, this goes back to my earlier point. If a homeowner is requesting IDR, let's say they have an attorney also, and it's not required under the CC&Rs, you might, depending on the case, not always, but depending on the case, the board might decide, ideally with a recommendation of counsel, that a mediation is maybe the better way to go. And keep in mind, if they go that way, the board would have to pay for that first mediation. That is a Davis Sterling requirement, that the fair, reasonable, and expeditious procedure be free to the party requesting the procedure. But on balance, it might be more cost effective, depending on the circumstances of the case, to just go quickly to a mediation and try to resolve it with a neutral third party. And the reason is because, as that question was suggesting, most of the time, at least in my experience, an IDR meet and confer process does not result in a settlement, at least not a settlement with any enforceability mechanism. The reason is because more often than not, they try to do this without attorneys, and they might have a handshake deal and then realize they didn't see eye to eye. And then it's a he said, she said type of dispute because they didn't have attorneys who helped them reduce the terms to writing. That's one major reason. And then the other reason is just the reality that if you couldn't informally work it out in the first place, just because you call something else informal and you meet by Zoom, or you meet in, the conference room, common area, are you going to really resolve it without attorneys and maybe without a third neutral party facilitating it? It's a decent question, how productive it may be.
Yeah, and then I think implicit in this, I mean, is whether the IDR is required. Are you required to do an IDR or not? And
Right.
I believe the Davis-Sterling Act doesn't require that you do the IDR. It requires that you respond, but
Right.
not that you don't actually have to do it. And if somebody uses the IDR belligerently, if that's a word,
Sure.
they use it to beat up the board, then you can just say, thank you for your IDR request. We deny it. We're not going to talk to you. Then they have to do the ADR, right?
Exactly.
And then once you do the ADR, now that's a whole lot more serious situation. And that's where the dollars can come in. But what you're also talking about is that you may have in your governing documents language that tells you how to deal with conflict resolution. And so that trumps what's in the Davis-Sterling Act, if I remember right. So if you have it in your document, if you have it in your governing documents, how to deal with it, and it's a reasonable process and a fair process, that's the process you use.
Right. And it's not so much that it trumps or supersedes the Davis-Sterling Act. It's just important to understand that the Davis-Sterling Act provides a floor, a minimum of what you're supposed to do.
That's
and
right.
CC&Rs have the right to ask for more procedures.
Right. And from my experience, most of our homeowner associations don't have the conflict resolution procedures in their documents. Some do. I would say it's probably a good percentage, but it's not the majority. So you defer to the Davis-Sterling Act for that. If you have them, that's great. You got to follow them, and as long as they're as restrictive, if you will, or as much useful, if you will, as the Davis-Sterling, which you find in the Davis-Sterling Act. So you just need to, you need to have that process. Some way you need to be able to deal with these issues.